Hello guys, and welcome to another episode of my lecture. On today's episode, we are going to begin a new class of type of evidence. And basically, we are going to be talking about the relevant fact evidence. Do not forget that during the introductory part of evidence, when I was introducing this course to you, I told you that the only reason you are in court is to prove a case. Right? You would not be in court except you are trying to prove something before the court in order to accrue a liability to the other party and get it compensated one way or the other. That's the reason you are in court. That's the reason we are all in court. Do you understand? We are trying to prove something. Now, when we get to the court, there are certain things that must be proven. Those things are the facts in issue in our case. The things we are going to prove in court are the facts in issue. However, there are certain facts that are relevant to the fact in issue, which means that while the fact in issue is standing on its own, some other fact can help us shed more light on the fact in issue. Some other facts are so relevant that they can help us prove better the fact in issue. Those are what we call the relevant fact evidence. And the first one is the res gestae evidence. Although it was quite lengthy, I taught you in the last class that when we are talking about the res gestae evidence, we are talking about statements made contemporaneous to a particular action that can shed more light on that action. Do you understand? And we peruse through a lot of cases, both Nigerian and English cases. In fact, we even perused through two different dispensations. The first one was the strict contemporaneous, and the second one was the sufficient contemporaneous. And we've understood what those mean. Now we are taking the next step. We've gotten section 4, right? Now we are going to section 5. What does section 5 say? And after that, section 6. What does section 6 say? Section 7, section 8, section 9, section 10, 11, 12, and 13. Do you understand? Because, section 14 is illegally obtained evidence. That's something else. That's evidence which are obtained illegally. That's, totally something else. So now, starting with our class today, relevant fact evidence, section 5. That's basically what we are starting with. Do you understand? So what does section 5 say? Section 5 talks about facts which are the occasion or cause or effect of fact in issue. And then section 5 tells us the facts which are the occasion, cause or effect, immediate or otherwise, of relevant facts or facts in issue, or which constitute the state of things under which they happened, or which afforded an opportunity for their occurrence or transaction are relevant. I would explain this. Let us look at the rules in this section. A number of events showing how an event occurred or which facilitate the happening of such events are relevant. Under this section, a lot of circumstantial evidence is admitted to prove a case. In the case of R versus Stewart, the fact is that marks were found at the scene of a murder. The court held the facts as relevant because those facts can help us prove certain things. But before I go into the explanation, other facts pointing to circumstantial evidence may be admissible as relevant facts under this section. For example, footprints. Let us look at the case of R and ABADON. In the case, the fact is that the appellant broke window during a robbery and fragment of glass from the home was found in a pair of shoes taken from his house. An expert witness testified that the both pieces of glasses were identical and it was very likely that the glass in the shoe originated from the window. The court held this piece of evidence as admissible. Now, in the case of ISIBOR versus the state, the accused was charged with armed robbery. The fact was that he was the only person in the said stolen car which he admitted he stole 5 hours after the robbery with no other evidence. The court held that it was relevant using the doctrine of recent possession and circumstantial evidence. Note that this section covers not only circumstantial evidence but also evidence which proves the cause of a thing, the happening, that is the occasion itself, and also its consequences, that is the effect. However, this section cannot be used to admit hearsay evidence, as in the case of OZUDE versus IGP. So basically, Section 5 tells us three things. It gives us three rules. It tells us that when a particular thing has happened, occurrence A, anything that made occurrence A happen, that is the cause of occurrence A, is admissible. And also, anything that is the effect of occurrence A is also admissible. Do you understand that? So, for example, a person has been shot to death, and then they were able to retrieve the bullet from the person's body. And while they were tracing the bullet, they traced it to a particular shop. They traced it to the fact that the accused in this case came to buy a gun from that shop. Now, while they were tendering that into evidence, while the person was in the witness box, and then the person was talking, the witness was talking that yes, the accused came to buy a gun, the counsel for the accused objected and said no, that is not relevant evidence. Now, the question the court has to look at is whether Section 5 will apply in this case. So somebody has been shot. It would be irrelevant to the case if we cannot tie the gun that the accused has come to buy to the death of the deceased. That means that if we can say that the gun, the bullet that was given, is identical to that which kills the deceased, then it is relevant. But also, if the accused went to buy a gun, it is also relevant. However, other surrounding circumstances must also give it more relevance. Do you understand what I'm saying? So when you are looking at occurrence A, anything that could have been the cause of occurrence A, for example, somebody going to buy a gun in a shop, which if objected to, the court can now decide whether or not is the cause of A. Because had they not bought the gun, there would have been no instrument to shoot A. Do you understand that? So these are things that we look at when we are admitting under Section 5. So when you are looking at occurrence A, look at the cause of occurrence A, look at the effect of occurrence A. After occurrence A happened, what could have happened? So if you look at the case of R versus ABADON, that one is explaining to us the effect of occurrence A. So what was occurrence A in this case? Occurrence A was the fact that there was broken glass at the scene. The effect of the fact that there was broken glass is that the remnant of that glass could have dropped anywhere. That's the effect. And then the remnant of the same glass at the window was traced to the accused's shoe in his house. Now that's an effect of occurrence A. Do you understand that? So when you're about to answer evidence question and you see something like this, where they give you something about something that happened before or something that happened after, in your mind, whatever it is that they are giving you is occurrence A. What could have caused it is admissible. The effect of that thing is also admissible. But note that occurrence A itself must be in relation to the fact in issue. The effect need not be in relation to the fact in issue. The effect only needs to be in relation to occurrence A. So for example, somebody has gone to buy a gun, like I painted earlier, which is the cause. Going to buy a gun is not a fact in issue. So going to buy a gun in itself is not in relation to the fact in issue. Do you understand? Going to buy a gun is not in relation to the fact in issue that somebody has died. What is the problem here is that a person has died by gunshots. That's occurrence A. The fact in issue is somebody has been killed. That is not what we are talking about here. What we are talking about here is that a person has been killed by gunshots. What is the cause of that? That means that somebody who killed him had a gun. How did the person get the gun? That's the cause of occurrence A. Now, the effect of occurrence A, that the person has died, is that his body will be taken to the medical doctor for autopsy and all that. Anything that is surrounding the effect of occurrence A would still be admissible. Do you understand that? So, we've looked at the case of R versus ABADON, which talks about effect. We've looked at the case of ISIBOR versus the state, where the accused was charged with armed robbery. The fact was that he was the only person in the stolen car, which he admitted he used. So now, what is the occurrence A here? The occurrence A here is that there has been armed robbery. What is the effect of armed robbery? The fact that the person who is the robber in this case is going to go away with certain goods, which is stolen goods. 5 hours after the robbery, they caught him and he admitted that that stolen car was the car that he robbed. You can see that the admission of the effect of occurrence A is relevant to the fact in issue. So what is the occurrence here? The fact there has been an armed robbery. Abi, what is the effect of occurrence A? The fact that the person who had robbed must be with the stolen property. So for example, if I go to the street now and I carry gun and I say, hey, Alaye, give me your phone, and somebody gives me their phone, what is the effect of what I've done? What I've done is that I have robbed. That is occurrence A. Yeah? The effect of it is that I am now in possession of stolen property, which is the effect of occurrence A. Do you understand? Me being in possession of stolen property is admissible in court by virtue of Section 5 of the Evidence Act. Do you understand that? Also, the court used the doctrine of recent possession. Recent possession is under the criminal code, but that is not something I want us to talk about now. But it's still relating to this, where you have stolen something and all that. So, permit me to digress a little and let us go a little bit to the UAS case. In the UAS case, if you haven't looked it up, kindly go to my YouTube channel and look the UAS case up, where certain people allegedly raped Ua in a church, and after doing that, they stole her phone, and then one person who did not even know what was going on decided to buy the phone from them, and he was as well arrested. Now in this case, the question is, but he said that he was not a party to the raping, he wasn't a party to the killing. Why is he being arrested? Because they have a Section 5 against him. They have a Section 5 of the Evidence Act against him. And what does Section 5 tells us? Where there has been an occurrence A, the effect of the occurrence A is admissible in court. The occurrence A here is the fact that Ua is dead. The occurrence A here is the fact that Ua was robbed. The effect of the occurrence A, therefore, would be that whoever robbed Ua should be in possession of Ua's phone within a reasonable time of that thing happening. And that's the reason why that boy ended in the police custody. Do you understand that? So I want you to know that in this case, you are thinking like a lawyer. You're not thinking with emotions. You are thinking logically according to the sections of the Evidence Act. So we then move to the latter part of the lecture that says that, note, this section covers not only circumstantial evidence, but also evidence which proves the cause of a happening. That's the cause. The happening itself, that's occurrence A, and its consequences, that's the effect. So the before, the now, and the after. Those three facts are admissible before the court. I know that I've been talking about the cause and the effect. Also note that you cannot be talking about the cause and the effect of something if you have not admitted occurrence A in evidence. Do you understand? Occurrence A must be before the court, and then the court will then admit what would cause occurrence A to happen and what would be the effect of occurrence A. For example, in the case of R versus ABADON, occurrence A there was the fact that there was a breaking in. So if you had not admitted the breaking in through the window where the glass was shattered, how will you then be admitting the glass inside someone's shoe? Do you understand? So you must have admitted occurrence A first before you admit the cause or the effect. Because if you just jump into admitting the effect without admitting occurrence A, then that's the problem. Because then the court will say, I don't follow. Because there's no nexus. You are coming here to show me that there was glass in his shoe. There could be glass gotten from anywhere. But if you lead first by showing that there was a breaking in to the house, and then you show the speck of glass that was broken, then you show the relation to the glass in the shoe, then there is an effect which then connects to occurrence A and thereby showing a nexus. Do you understand that? So, like I said earlier, you didn't show that someone has been killed through a gun bullet, but you are trying to show that someone went to buy a gun. It is very, very irrelevant. It has nothing to do with occurrence A or whatever the case is before the court. So you have to first admit, oh my lord, someone has been killed by a gun, and this is the bullet. Now I want to show you that these bullets can be gotten from the same shop. Do you understand? Where this guy came to buy a gun last night. Now you can see that piece of evidence where you went to buy a gun at a particular place last night would have ordinarily been irrelevant if I had not admitted that someone is dead and this is the bullet that we retrieved from the person's body. Do you understand that? So with that, I go to my next lecture where I'll be talking about section 6, bordering on motive, preparation, previous and subsequent conduct. I'll see you in my next class.